Okay, so for our best answers for the reclamation process, Empress's best answers for number one is the question was, what is an imperial government? An imperial government is a form of government that controls an empire. Lands and foreigners are subject to taxes and laws of the ruling powers, the indigenous nations. We refer to our government as an imperial and tribal government. Number two was the highest law of the land. The question was, what is the highest law of the land? Natural law, Me'at, is the highest law of the land. Nature, all things that are changeless, is the highest law of the land. Then you get into the written law. There's first a spiritual law that is changeless and unseen, and that also has to do with the laws of nature. Number three, what does interregnum mean? Interregnum is a period when an empire or reign has paused or suspended for a period of time, such as the empire in America that went into interregnum in year 1913 and was brought out of interregnum in year 2016 by an act of Congress, where it can be found in the records of Congress, the Library of Congress, under TXU 002049663 is one of the articles, one of two. Number four, the question is, what are the first two factors prior to adjudication of any legal matter? That is status and jurisdiction. Number five, what year did decolonization become effective? Year was 1961. It was solidified by the United Nations Declaration on Decolonization, also known as Declaration 1514. Number six, what are the absolute laws of the land? America, not according to the Constitution. We just talked about that in number one, or number two, the natural law, universal laws, which are spiritual laws, and then you have the law of heirs, the laws of the land, a law that is changeless. Number seven, what are the laws of the land according to the Constitution? Treaties made and shall be made, and that shall be made, laws of any state to the contrary notwithstanding. Number eight, where did the Prophet Noble Drew Ali derive his authority? He himself said, from Allah. Number nine, what year did Empress Ninti El bey establish her absolute claim as heiress to the land? The first claim was in year 2007. And then the ultimate claim was in 2016, which is filed at the Library of Congress. What is your understanding, number 10, what is your understanding of immunity and exemption as it pertains to the Aboriginals, an Aborigine of the land? Freedom from a general duty or services, immunity from all taxes and charges. Aboriginals, Aborigine of the land, are not bound by laws of foreign jurisdiction. We are cost exempt, levy exempt, and tax exempt. Number 11, Name 3 documents standing as law that confirm the immunity and status of the Aboriginal. Number 1 is the Law of Ninti, which can be found on our tribal website, aborigineofamerica.com. And then we have number 2, the proclamation, ancient imperial Moors are out of interregnum. That is the Library of Congress document and proclamation declaration that was filed and received and accepted by the Library of Congress in 2016. Number 3, we have Aborigine Charter of 2017, and that contains the fee schedule for any violations against us, our tribe, or tribal members. Number 12, what is tribal sovereign immunity? It is a legal doctrine by which the sovereign cannot commit a legal wrong and is immune from civil and criminal prosecution. Number 3, name the case law which references and established the doctrine of sovereign immunity. This is the Supreme Court case first acknowledged tribal sovereign immunity in the case Turner versus the United States. This was in the 1900s. The exact date will be your homework. Most Turners changed their names from Tunica in an effort to save their lives from foreigners killing them for their land in the South. This was a common thing that happened to many indigenous bloodlines. The changing of the names and going into hiding to preserve the bloodline. Number 14, where can we find the fee schedule for the Aborigine Moors Empire? It's located inside the Aborigine Moors Charter. Number 15, who shall protect the Aboriginals of the land? At law, the Provost Marshal and Army of the United States of America. I want to rephrase that. That is what was originally written, but I'm going to just update that to the Army, not the United States Army, but the American forces are the protectors, Homeland Security, as we see on the ground right now. We have the authorities and powers to govern and protect ourselves with our own bashaws, muftis, and imperial army as well. Number 16, where can you find the ancestral imperial words of King James in the Bible as it pertains to the inheritance of the empire? That is Joshua 1 and 3. Number 17, what dictates jurisdiction and from whom? Status dictates the jurisdiction of an individual. Jurisdiction is derived from birthright of the individual. Number 18, what provisions in law gave Ninti El bey the authority as empress on the lands of America? The Aborigine title claim of heir of provisions, which is a mandate of heaven, and heir conventional, absolutism. First in time is first in line. That is the law for all ancient bloodlines. Number 19, what does ab asudis non fit injuria mean? This is a definition that's in the older dictionaries and in the Black's Law Book that talks about when you do not stand firm on your claims and convictions. It says, from the things to which one is accustomed or in which there has been long acquiescence, which means acceptance, no legal injury or wrong arises. If a person neglect to insist on his or her rights, he is deemed to have abandoned it. These are actual laws that are being put into place that most people do not know about. And ignorance of the law is no excuse. So you can't expect a judge or an attorney or anyone in the legal field to put you up on these type of laws because they're not. They're going to stand mute. It's not their job to practice law from the bench or to give you legal advice. This is why it's very important for us to do our own legal research and be well equipped in the law. Number 20, in what article of the Constitution will you find mention of the treaties? That's Article 1, Section 2, Paragraph, and Article 6. Number 21, are there any laws that supersede the United States Constitution? Yes, there are. The absolute laws of the empire and royal high courts of the land, which are represented by the imperial tribal governance. So tribal governance has taken precedence over the land. That's why we have Homeland Security on the ground as well as the National Guards. They are all under homelands, or they are all under the American forces, the American Army, okay, the Pentagon. All of these departments are under the Homeland Security. When you see Homeland Security on the ground, that means a beneficiary of the land has invoked or ordered them to be on the land. No other way can that happen. You have never seen that before in our timeline legacy that we are in right now. And as far as the National Guards, they are under the orders of Homeland Security. But Homeland Security itself, we have not ever physically seen them in the mass numbers and magnitude that they are right now. Number 22, who does the United States Constitution apply to? Okay, first of all, the U.S. Constitution has been created by the United States Corporation Company and its executors. Okay, that's a corporation. So it's really not a constitution. It's like bylaws of the corporation. So the U.S. persons and trustees are under the guise of the Constitution, so to speak. It applies to the U.S. persons and trustees of the chattel paper or chattel property of the U.S. corporation. Number 23. What is the meaning of jus soli? Jus soli means birthright to the soil. That is a law. Born in the United States no longer makes anyone automatically a citizen. That was the law previously. That is no longer the law. Birthright citizenship is now void of law, is no longer available in America. So just because a person is born in America does not give them birthright citizenship. Number 24. What does the term out of interregnum mean? End of a period where government was suspended or inoperative. or laid dormant for a period of time. So that means that the bloodline and the powers of rulership never went away. It just lay dormant until it was resurrected. Okay, number 25. What is interregnum? An interval between reigns, the period which elapses between the death of a sovereign and the election of another. The vacancy which occurs when there is no government. So when we say election in this sense, we go back to the claims and the heir of provision. And an heir of the land or a certain bloodline stepping up to reclaim their ancestral estate. In the case of me, myself, and I, Empress Ninti El Bey, born Eureka Micheline Ramjour, and evolved into Empress Ninti El Bey as I have learned my titles of nobility and birthrights as a ruler, tribal leader, and a descendant of ancient rulers. So I brought all of that back to the forefront and made it public knowledge, known by articles of the charter and by public notification, publication by notice, actual lawful and constructive notice to the constituents of the United States and the governments. In the year, starting in the year of 2005. So it's been a gradual process up to this day. So that's 20 years of demonstration, of proclaiming first, the proper status, and then the reclamation of inheritance, lands, and entitlements and properties. And along with that comes the right to have governance and autonomy of rulership. So in year 2016, by proclamation filed at the Library of Congress, was done by Empress Ninti El Bey. And that document is called Ancient Imperial Moors Are Out of Interregnum. Number 27, do you know the hierarchy of the land? The hierarchy of the land starts and ends with the indigenous inhabitants to America, the Aborigine Moors, who are known in her story and our legacy as the governors of the land, the lawmakers, the lawgivers, and the law enforcers. Next, we have the indigenous inhabitants of the land and the indigenous tribes who have tributary powers upon the land. No indigenous power is greater than the next. Everyone is respected for governing their own territory. Okay, the indigenous inhabitants of the land and their status will always supersede any other because our status, our bloodlines existed before the courts. The judges, attorneys, foreign interests, colonial powers, colonial interests, we existed before the courts. Number 28. Where is the Empress's powers derived from? Her lineage, absolute law that she has proclaimed and put it into perfected law, filing and proclaiming. The law of heirs, mandate of heaven, the law of Ninti, abstract of title upon the land, annexed and recorded in Mecklenburg County Register of Deeds, Imperial City, instrument number 20100095813, and at the Library of Congress, proclamation number TXU 02049663, one of two documents, as well as other filings and certificates of ownership filed at the Library of Congress, as far as seals and family crests and other documentations and books as well. Number 29, what is the name of the Library of Congress proclamation filed by Empress Ninti El bey in year 2016? That proclamation is named Ancient Imperial Moors are Out of Interregnum. Number 30, who is the prophet Noble Drew Ali, and what did he bring to the Moors? Number letter A, leader of the Moor Science Temple of America, who was accepted as a prophet. B, he established a Muslim order and brought awareness of nationality back to the Asiatics of North America. Number 31, who is Empress Khalifa and what territory did she govern? Empress Khalifa is an ancestor and was a warrior, a empress that led an army of warriors to fight in a Muslim war against Christians. She governed the territory that is present-day California, known to many as Khalifa territory. So if we know she led a war against Christians, we know the timeline that happened in. So it wasn't that long ago. This was in the 1900s during the Christian Crusades that attempted to overrun and overtake the lands of America. This is why there are so many warriors in Khalifa territory. They have factioned themselves as street gangs, but the energy came from bloodlines of warriors. Number 32, what are maxims of law? General customs and common laws of the land, usually known as 12 maxims of law. Number 33, and the last question on the test. What are the first 3 steps to any judicial action before any judicial action can commence? These 3 things must be determined before any court of law or legal judicial action can be commenced or brought against anyone. First, the status has to be determined. Second, the jurisdiction. Third, adjudication. Okay, so if the status is not properly determined, or if a court or judicial venue does not have the jurisdiction over the status of the person or the subject matter of the person or the entity or the living soul, that proceeding cannot move forward, because you got to have, in court, they have to have, to determine that they have the full jurisdiction, they have to have subject matter jurisdiction and persona jurisdiction. That means power and authority and jurisdiction over the person and the subject matter that is taking place. So if they cannot determine that, there's no way they can move forward with any charge or case or determination in that matter. because if you're indigenous to the land, you first of all, you're not a corporate entity. Only corporate entities present themselves in court. This is the thing that trips up a lot of folks. The all caps that they trick you into coming into court with, that is putting you under a corporate status. You have, because they have to have apples with apples and oranges with oranges, just like with anything else. So if they do not have you in the capacity where they can do business with you, then they know automatically they cannot bring you into court. So they always present an offer to someone in all caps, and that signifies that they have turned you on paper into a legal corporate fiction. And that's the only way they can deal with you. So for me and my tribe, we do not give them the opportunity to put us in a category that is not of our status. And that's where you got to nip them in the bud right then and there. You cannot go past our status. And that's why it's so important to put your status on the record way ahead of time. Your status has to be uh, placed in an inconspicuous manner in public record so that everybody can find it. Everybody that's challenging you or wants to know anything about you can find out what your status is just from looking up your name in documents and things like that. So this is why I'm a strong advocate about making sure that everyone knows their proper status. Because to know your proper status is to know your rights upon the land. And everything falls after that. You have to know the status. The court or anyone dealing with you, challenging you, or wants to make any type of legal claim or presentation against you, action against you, must determine first if they have the power to do that. And that starts with the status. If they can determine they have the status, the jurisdiction, or the power to bring the charge, meaning that they have the power and the jurisdiction of subject matter and over the person, then they can move to number two, jurisdiction. Then they can say, well, we have jurisdiction over the subject matter. We may not have jurisdiction over the person, but sometimes they try to play the game like they can still make an assumption or make a determination because they think that you don't know, especially if you go in to a venue without lawful knowledge or a lawful representation. But at law, they have to have the jurisdiction over the person, the persona, and the subject matter. 9 times out of 10, they do not. Because if you make it known that you are indigenous to the land, that means you are coming in as a living sentient being. You're not coming in as a corporate entity. And so they have to deal with you how you present your status. Many times we get railroaded. It's happened to me many times where they try to railroad me into a situation that they could not box me into because I have always made my status known on public record, in affidavits, in claims, in court. It's well known. That's the protection that I had, and I thank God that I had it because it was widely known. No matter what they tried to do, it can be easily found what I have proclaimed my status to be, and no one can refute or rebut your affidavit. So that means they cannot move forward with adjudication. That means making any type of determination as to your status, as to your capacity, as to your lands or properties. It cannot be done. They do not have the power or the jurisdiction to get it done. Now, have they done it regardless? Yes. If they feel like you don't know how to stand on your square and stand on the law, they're going to try you. That's why we do this test for everyone that wants to come into our tribe. You have to know the law because the law sets the blueprint for how your status is going to be protected and how you can stand on the law to protect your own status and your children and your lineages to come. Does that make sense? So that is the end of my dissertation on this matter. I'm going to conclude this live. This is for the recording of the tribal members, educational purposes only, and for anyone who wants to enter into the Cherokee Nation of Moors or have their reclamation done in their own tribal bloodline. It can be done as well. All right. Peace and love. I hope that helps in the education process. Till the next time.